I guess, are we ready to go to you, Paul?
Sure. You bet.
Thank you.
Thank you, Anne.
You know, another thing about those license plates, it's not a bad thing to have the word stop on the back of your car. For those of you who've ever been rear-ended, you know what I'm talking about.
Yeah. So, thank you. I'm going to follow this.
Yeah, I forgot to mention something. Is that on?
Oh.
I forgot to mention something real quick.
And let's see about that. It's better.
Can you hear me now? I just wanted to mention this. Also, we have what we call our Speak Up campaign, and that kind of comes from the Mickey Grady testimony, where he talked about Speak Up, and we're talking about Speak Up for seniors. And we have these little business cards that have all the warning signs of elder abuse, and they have the elder abuse hotline, 24-hour hotline that you can call to report abuse. And we thought this would be a great thing for people, if they wanted just for themselves, they could keep it in their wallet or whatever. But if you're a professional and you think you might use it, to take a bunch of them and keep them handy where you can pass them out as needed. Thank you.
Thanks, Anne. All right. Well, this last segment, it's never a good time to talk about neglect either before lunch or after lunch. But I guess actually after lunch is probably preferable to the before. So I apologize, but I was asked to cover this. And I have to tell you that in all my experiences of prosecuting, probably now, I don't know, over 500 cases of felony cases a year, in 15 years, physical abuse, the pictures speak for themselves, and I showed you some of those today with the black eyes and the bruises. The financial abuse can be very effective in presenting that to a jury. They feel for the victims, they feel the hurt and the impact and the betrayal of trust. My experience of elder neglect is it has to take something really, really shocking to get jurors engaged. And I'm sorry to say, but I've found that jurors get more angry over neglect of a puppy than they do of an elder. And I don't get it, but that's my experience. And I still remember the first case I prosecuted in front of a jury. The judge, and unfortunately came back guilty, but the judge came to me afterwards and said, "Be very careful, Mr. Greenwood, about your use of filing neglect charges in this county." He says, "because we don't want to give the wrong message to the citizens of this county that if you take care of an elder, Greenwood may come after you for having fallen below the necessary standard that he expects of you." And I took that to heart, and there's a lot of sense in that. And now I'm seeing proof of what he means. This case actually was published in the Los Angeles Times 3 days ago. And actually on Wednesday of last week, I think it was. No, June 2nd, yeah. Maybe Tuesday. Maria Lopez, living with her great niece, dies weighing 35 pounds, covered with sores. And the question that the journalist poses is, was the 91-year-old's death murder or natural causes? The case was prosecuted in a county called Madera County, which is in the Central Valley, an agricultural part of California. And the DA up there charged it as second-degree murder. They also charged a felony elder neglect by a caregiver. And this is the photograph of the caregiver, the defendant, who was the niece. The jury came back not guilty on everything, and they couldn't even agree on a guilty verdict for a misdemeanor elder neglect charge. And yet, apparently, there were very vivid photos, there was expert testimony from the doctors that she was living in an appalling condition and had been neglected by this caregiver. What the defense portrayed
as I think you can imagine, is that she was the only one out of the whole large family who stepped up to the plate and tried to do something. And that's how the defense portrayed her, that she became overwhelmed, and that she never, ever intended to harm her great aunt, but it just was, she was a victim of circumstances too, and that's what the jury thought. So these cases are very, very tough to present as criminal. And so I think my experience tells me that if we are going to prosecute, I think we have to be very careful about using a homicide charge in a neglect case. It has to be very, very convincing, not just from a negligence standpoint, but I think there should also be some financial element attached to it if we're going to prove murder. Because we've got to look for the motivation here as to why did this caregiver allow this person to languish. I just also want to show you a case that I issued several months ago, but after I issued the case, I changed my mind. And 2 weeks ago, I dismissed the case on my own motion. The case involved a mother and a daughter, and I charged one count of felony elder neglect. The daughter was a county employee who was off on illness grounds, mental illness grounds. And it became very clear that she had some delusions about the neighbors. She built this fence all around the house to protect herself and her mother from what she considered were the enemy. The day she was arrested, this is what the suspect's daughter was wearing. This is a bicycle helmet, and she was wearing that because she explained to the police officers to protect her from all the electronic rays that were being sent into the house from the neighbors. And she wore around her neck some kind of collar, and inside were Brillo pads, again to protect her from the electronic rays. The suspect actually slept in these trash cans in the living room. And the reason is, again, to protect her from the incoming assault of electronic rays. The day of the investigation, his daughter, called 911 and said that her mother had stopped breathing. This is a photo of her mother laying there on the floor. And the police arrived with the paramedics afterwards and found the mother laying on the floor, and she was already dead. And I'll just show you one brief photo of her like that. Okay. She had been there for over 3.5 weeks on the floor. And the daughter had known that her mother had fallen. The daughter said she had fed her. She said that she made some efforts to keep her comfortable, but she was afraid to take her mother out or bring people in. And in the end, her mother died. And the coroner did indicate that a contributory factor to the death was a delay in seeking medical attention. So as a result, I charged felony neglect. As the case proceeded, and we went in front of a very pragmatic judge who's been around a long time, it was very clear to him and to the other court staff that this defendant was clearly out there and had serious mental problems. And as a result, I decided that I wasn't going to pursue it any further. She came to court with a service dog. The service dog was beautiful. I felt that the jury would be much more sympathetic to the defendant, and I just didn't think a jury would become excited about this case. So I dismissed it. And again, I wouldn't normally do that with any other case, but with neglect, it's really, really tough. So gathering the evidence, first of all, does the suspect, caregiver, make a 911 call? In my case, she did. It was a very flat tone, but it also showed some eccentricity,
and some bizarre behavior by the suspect. Again, who were your first responders? I do want to know who they are, get the names of the paramedics, and remember, using the paramedic as a key witness, probably in this kind of case, would be vital. In this case, there had been very little prior adult protective services reports of neglect, or some neighbours had called in to say that they were concerned for the mother because the daughter had been acting strangely by putting up a fence and doing other things. But there was nothing really substantial where the APS had gone in and found mother to be in a bad condition. In fact, I think one time they went in there and they found mother to be living in fairly clean surroundings. Neighbour statements definitely can be very useful. They know what's going on. Of course, photos of the living conditions, and sometimes in these neglect cases you do get a stark contrast between what the victim's sleeping arrangements were and the suspects. In this particular case, I couldn't show that. Mother was on the floor, but so was daughter. Was sleeping in trash cans. So I couldn't really even, compare that. But in other cases, we've been successful in showing that the suspect was living in a beautiful, neat room, whereas the victim was left in squalor. I also like to find out if there can be any evidence of any addictions attributed to the suspect caregiver. Gambling, narcotics, alcohol, where you can portray the suspect feeding these addictions to himself or herself while not caring for the elderly person. And then, of course, just general evidence of the suspect's role as a caregiver. What kind of participation did they have in the life of the caregiver? Were they actively running out every day buying groceries, getting the medications for the victim, or were they simply doing the very minimum? I also urge law enforcement not to arrest a suspect in a neglect case. As you know, when you arrest somebody, that means the time clock is ticking. And in California, I'm sure it's the same here, we have 72 hours within the arrest period, after the arrest period, in which to make a charging decision. Otherwise, the suspect is released from custody if no charges are filed. Neglect cases are not like a physical abuse case or a financial exploitation case where you can make an immediate decision on reading police reports. In most neglect cases, you cannot or don't want to make that immediate decision. You don't want to be under the pressure of in custody, time clock ticking. So I'm always saying to my detectives, please don't make an arrest. Investigate, but bring the case to me and then we'll make a decision. And besides, in most of the neglect cases, the caregiver is not a danger to the public. It's not a flight risk. It's less compelling than that. Also, when the suspect is not in custody, you have an opportunity as a law enforcement officer to interview them without having to give them their Miranda statements. Remember the Miranda portion is only given in anticipation of interrogation, which is considered to be, quote, custodian, which could still be on the street corner surrounded by 3 police officers with guns. That could be considered a custodial interrogation. But, for example, a telephone call to the suspect by the detective, that's not custodial in any way, and so that can be done without Miranda. And you have more chance of getting information from the suspect when the situation is not custodial, to establish whether they admit to being a caregiver to the victim, and also allow the suspect to come up with any possible defences. So you can anticipate those defences and look to see if we can overcome those defences. In most of the neglect cases that I have, pressure sores play a part. People call them bed sores or decubitus ulcers. And the question becomes, in some of the neglect trials, are these pressure sores avoidable? And there are some experts out there who will always refer to Christopher Reeve. He unfortunately did suffer from pressure sores as being confined to his wheelchair in bed. And most experts will tell you that even under the best conditions, in the best nursing homes, some pressure sores are totally unavoidable. Of course, you can minimize the risk by moving the patient every 2 hours and readjusting them. But stage 1 bed sores are typically unavoidable. And without getting too graphic, I will probably only ever contemplate a criminal prosecution when it's stage 4. I will never think about doing an investigation for stage 1 or stage 2. Probably not stage 3. I normally have to have stage 4. So if you are, as a police officer or detective, being asked to investigate an alleged criminal neglect and there's pressure sores, one of the first things you need to do is have the expert medical person tell you what stage these pressure sores are at. And according to my medical experts, there are lots of factors that influence the possibility of a victim developing pressure sores and for those pressure sores to deteriorate more quickly over time. One is the victim able to get up and down, get out of bed on their own, or be reliant upon being turned by caregivers? What kind of mattress did the victim have in their home? Because the mattress can often lessen the risk of getting pressure sores and other medical ailments and conditions associated with the victim. I end up normally looking at cases like this, which I think may have a chance of being successfully prosecuted in front of a jury, where you've got a combination of several of these factors here, where you've got proof that the suspect deprived the victim of medical attention. But with that comes a problem, because this will be one of the defenses that will be raised, and you probably hear it all the time, particularly in our dog protective services, when you're maybe investigating an allegation of neglect. Why didn't you take her to the doctor, you ask? And the response was? She wouldn't go. She doesn't like doctors. She's always made it clear that she doesn't want doctors. And there's something that I always ask about. Does the victim have a living will in which there is a directive, in which she says or he says, I don't want any medical intervention? There are some elders on religious grounds who will refuse medical intervention. And so if the suspect tells you the reason they didn't take the victim to the doctor is because the victim refused, there's not a lot you can do with that. What about starvation, depriving them of food? Again, if the victim has already died, then hopefully the autopsy will reveal through the toxic screens the actual fact that the victim was starved to death. There is ways for a coroner to come to that kind of conclusion. Lack of hygiene, well, that's pretty obvious. But again, what was the victim used to? Maybe it was the victim's lifestyle. Maybe the victim raised the suspect in that kind of lifestyle, not to take care of himself or the victim. But again, if the suspect is somebody who presents as being tidy, clean in their own room, has a car, which is fairly respectable, but then you've got a victim who is terribly unhygienic, then I think there's more success of proving neglect. Yes?
How do these factors fit into a prosecution against the nursing home?
Right, the question is, how do these factors fit into a prosecution against a nursing home? The first issue there is, for a prosecutor, is who do you prosecute there? I mean, these things certainly play more into a nursing home
And I think a nursing home with supposed training standards, civil standards that they have to abide by, if these are being violated, then I think in some ways it's a lot easier to prove, and a jury would be less sympathetic to a nursing home, because after all, most nursing homes are in business for what? Profit. So this is a profit-making business, and if these conditions are present, or most of them, in a nursing home, I think it will be far easier. But then the question comes, who do you prosecute? The corporation, the director of nursing, the actual individual CNA who is taking care of that shift. Those are the issues that the prosecutor has to deal with. Very few prosecutions of nursing homes that actually take place. There's more success for civil attorneys to sue under the civil standards. But maybe the federal prosecutor will have something to say, because I have seen some federal prosecutions of nursing homes. Lack of ventilation, heat or light. In one case, we had a caregiver lock the Alzheimer's victim into their bedroom, went off to Las Vegas for the weekend. There was very little ventilation, very little heat or light, and so that was a pretty easy call to charge not only neglect but false imprisonment of the elder as well. Over-medication, is that an accident, or is something more sinister going on there? Under-medication, where is the medication going? Well, maybe the suspect is consuming it, and so if so, and you can prove the narcotics addiction, that will go a long way towards a successful prosecution. The victim I'm looking for is typically malnourished, but in the case I showed you at the very beginning, she was 35 pounds. That's the worst I've ever seen. So malnourished, semi-comatose, dehydrated, coated with feces or urine, for the climate, inadequately clothed, untrimmed toenails, and bed sores, or a combination of most of those. Oh, sorry, that was a repeat. Without dwelling too much on these photos, these are some of the cases that I've helped prosecute. So you've got the semi-comatose, dehydrated victim whose toenails had never been treated, covered in feces. Sometimes you end up with somebody on a medical examiner slab, absolutely full of bed sores. And again, you have to look to the medical examiner to say, what is the cause of death? Is the fact that these bed sores, did they contribute to the death? Did sepsis contribute to the death? And that is one of the more shocking ones that we have to deal with. Sometimes they're still alive. This person was found in squalor in a garage, in filth. This mother was found literally like that by paramedics, just utterly awful, malnourished, everything. And this is where she lived. The son was the suspect. We did prosecute him for neglect, and he tried to suggest that he had tried to treat the mother with iodine. He was trying to suggest that what was on the mattress here is iodine. I just felt sorry for the police officer who had to retrieve that evidence and take it away, but he did, and had it analysed, and that was just feces and urine, not anything else. But really, what I'm also ultimately hoping for in a neglect case, to get a strong sense of a conviction, it's always good to get some motivation from a financial angle. But here's my other dilemma. Sometimes the caregivers are being paid by the state to look after the elderly person. So you think, well, I can charge financial abuse there because they're obviously getting money and not doing what they're supposed to do. But then at the same time, you wonder, well, wouldn't they try to keep the victim alive as long as possible in order to keep the gravy train going? So there's that double-edged sword sometimes about financial abuse. But I always ask my detectives to look for signs of enrichment by the caregiver. Documents that give control to the suspect while the victim is becoming weaker and weaker physically because of the lack of attention from the suspect. Then the suspect is getting more control and power over the victim. So I'm looking for possibly a power of attorney that's been executed in the last 12 months. I'm looking for a possible quitclaim deed. If I'm lucky, we might even get a new will. Or a living trust that has been amended to include the caregiver as a beneficiary. I'm looking for bank statements. I'm looking for correspondence. I want the detectives to recover the checkbook, look for any withdrawals, look for pawn slips in the house to see if the caregiver has pawned any jewelry in the last 6 to 12 months. Because this will certainly, let's say, strengthen my arguments. And in almost every single neglect investigation, we're going to have to call upon a medical expert. Now in Virginia, you've got some wonderful schools of medicine and universities. I don't know any names, but I'm sure you do. But it is absolutely important that somebody in one of these universities, who's also hopefully a practicing geriatrician, will be able to look at your photos, look at the medical records, and give you an opinion that in fact neglect is present. For me, we're very fortunate in Orange County, just to the north of us, is what I consider to be in the United States premier geriatric physician. And this is Dr. Laura Mosqueda. If you ever had a chance to hear her speak anywhere on the East Coast, she really is really superb. She has done some very innovative work. She has set up an elder forensic center, first of its kind in the country, in Orange County. She does not only evaluates cases with law enforcement and APS and prosecutors, she has her own daily visitation. She does home visits to elderly patients. So she has her own caseload of elderly people. And it's just a fantastic resource. So I always try to refer cases to Laura Mosqueda, someone like that who can tell us what's going on here. For example, Laura Mosqueda, she can help define the functional status of the victim, just to give the jurors an understanding of what the risk is by letting the victim be deprived of medical attention, and how exposed and how vulnerable the victim is to becoming a victim of neglect. The doctor should also talk about what the appropriate diet is for somebody in their condition and age, what their hydration status was. Many of the cases of neglect actually involve dehydration. But again, dehydration can be something that happens through no fault of anybody. I look at my own father. In all the years, I've never seen my father drink a glass of water. Never. And the last time I was home, I kept badgering my mother. He's got to drink water, drink water. I mean, I finally got the hang of it. What they say is it like eight glasses a day or something? All of us need. My father has never drunk a glass. What does he drink? Tea, coffee, beer, and don't forget the brandy. But he's 88. I can't argue with it, can I? You know, but his skin, I know he's dehydrated. I know it. But it's not my mother's fault because she just can't make him drink. Also what helpful is for a doctor to be able to compare this person with another elder with similar medical problems and challenges, but who's actually received proper attention, and try to show the vast difference, how a proper medical treatment can help. And of course, this won't affect the prosecution if the defense is, my mother didn't want to go to a doctor. I mean, you're going to end up probably not being able to issue that case, because that is normally an insurmountable defense. What I know Dr. Muscali keeps talking about is she wants to know, before she enters the courtroom, what the prosecution expects. You know, what theories the prosecution is trying to portray to a jury, so that helps the medical expert know how to prepare and what questions to be ready for. And Dr. Muscali has always made this point to me. She says, it's very important when seeking to present your case to the jury is conveying to the jury what pain the victim has suffered. And try to avoid just jury disinterest and apathy. You know, how do you get a jury to be invested in this case? How do you get them to picture that in the remaining hours or days of a person's life, this victim suffered immensely through excruciating pain, what they went through? So, the defenses, and I've seen this a lot, at least I was doing something. The rest of the family simply didn't bother. You know, when I get calls a lot from family members who are complaining about the bad sibling who has neglected the mother or the father. And typically they're also accusing the bad sibling of having stolen some of the assets. During this conversation with the good sibling who is calling me, I will ask the good sibling, excuse me, when was the last time you saw your mother? And there will typically be a hesitation. What's that got to do with it? Well, no, just tell me, when was the last time? This happened in a conversation last week. And this lady was in Tennessee. She was talking about her mother in San Diego. And she finally said, 4 years ago. I said, why? Why 4 years? And the first thing she said was, don't you know how expensive it is to get from Tennessee to San Diego? And I said, man, that is no excuse. And I said, look, I'm just being the devil's advocate here, because if you're trying to persuade me that there is a case that should be investigated, you're not convincing me, because that's the first thing a defense is going to argue, is it not? That here is a sibling who couldn't even be bothered. And I often say, where were you on Mother's Day? Did you send your mother a Mother's Day card? Why didn't you phone? Things like that. Because the defendant will be portrayed by the defense attorney as someone who at least tried, and it was overwhelming for them, and it was something they were not qualified to do, but at least they were there, unlike the rest of the family. And I see this time and time again. She hated doctors. She refused to let me get help. So again, if that can be proved independently, then that's going to be almost insurmountable for him. His religious beliefs got in the way. He only wanted divine healing. Again, very difficult to overcome that, particularly if it could be documented that the victim was either Jehovah's Witness or a Seventh-day Adventist or somebody like that who did not want intervention medically. And if you've got a living will that was executed several years ago indicating no resuscitation, no medical intervention, that again is a very, very powerful defense. The case that we're looking at right now, which highlights, I think, the problem, but we still haven't made up our minds yet, but I think we're leaning towards issuing, whether or not we issue it as a homicide, I don't know. This is the scenario we have. Victim, widow, 84, has a daughter who are all dependent. 4 grandsons. 2008, 16-year-old grandson moves in with victim at her request, the victim's request. He was supposed to clean and cook. Now right there, you've got a 16-year-old boy who's being asked by his 84-year-old grandmother, move in with me. And I want you to help me by cleaning and cooking. Is that something we should be asking a 16-year-old boy to be doing when he has a mother living in the same city? Victim would visit neighbors twice a week, complaining of hunger. Daughter, defendant, or I said just the daughter, would check up on victim twice a month. So the grandson's mother would come over twice a month. Daughter reported having difficulty getting medical help for victim to treat her early dementia. She says she got into a lot of red tape and wasn't getting anywhere. In late 2009, victim was still able to communicate. Neighbors would see her outside watering the plants. Victim was always complaining about grandson about a pain in her leg. February 2010, grandson had a friend, A, move in. So another boy, similar age to the grandson, moved in. They would spend most of their time playing video games and eating at fast food places. The friend, A, described how victim would not use the restroom but would urinate and defecate where she lay. Grandson said he wanted to move out, but that his mother refused because she was unable to care for victim. So his mother refused to let the grandson leave. They discussed putting victim in a nursing home, but decided against it as this would deplete the living expenses. There's a red flag right there, isn't there? Daughter's visits dwindled to now once a month, not twice a month. In March 2010, police respond to a 911 call. Victim is found dead, emaciated, lying face down with broken crackers and crumbs next to her. And there she is. So the question is, who do we prosecute? Do we go after the mother? Do we now bring in the grandson who's now 18? Do we bring in the grandson's friend who was also there for several months and knew what was going on? And so this happened in February of 2010 and we still haven't made a decision because the coroner has been hesitant in making a decision as to whether this is a homicide or not. So I think what I'm trying to explain to you is I don't have an easy answer for these cases. We're going to see a lot more of these kinds of cases. All I would say is be very careful about, in a death situation, filing homicide charges in a neglect situation. If there's a felony elder neglect statute, maybe that's the way to go with your first one or two to see how jurors respond. And always have a good medical expert available for that. I've got some, it's great, I've got about 10 minutes here left, so I'd like to throw it open at this stage for questions about anything, financial, neglect, or physical, or anything else. Yes, and I'll repeat the question for you at the back.
One of the things that we see at legal aid fairly frequently, and I would guess this crosses all kinds of socioeconomic groups, is elders who are very reluctant to bring charges of any kind or support charges of any kind against family members.
Yes.
It's family, it's blood, you don't do that to kin. What kind of arguments have you used or heard that make any headway in the face of that kind of understandable sort of bone-deep conviction?
Right, good question about the reluctant victim and the suspect is a family member and you don't do it to blood relatives, you don't accuse them, you don't put them in jail. How do you overcome those? What I like to do with my victims is find out what is the root cause of why the suspect, who's a son or a grandson, niece, nephew, why they acted out in the way they did. And typically it's one of three things. It was either drugs, alcohol, or gambling that made them do it. And we will talk about it, and it's typically methamphetamine. And I understand in Virginia you may have had some experience, not personally, but experience with people, right, who've become tweakers on meth, and it's a huge problem in San Diego. So I talked to the mother about the addiction to meth, and I will say about, what have you tried? And she'll say, I've tried everything. I've tried getting him into rehab, but he just won't stay in the program. And then I'll eventually say, you know, I've heard of this great program, and you don't have to be involved in it. It's free of charge, and it's pretty effective. And they go, oh, really? Of course, at the end, I ultimately have to say, yeah, it's called jail. But ultimately, if I can convince the victim that I'm not simply wanting to prosecute their loved one because I want to punish them, actually, that we in the criminal justice system want to see this person rehabilitated. And in my experience, I'll say jail plus some residential rehabilitation program ordered by a judge, and knowing that if you fail to follow through the program, you will end up in state prison. That's a great incentive to follow through with that program. How about letting your son or grandson do that? And most of the times, I can get my victims on board. Because the trouble is the son or the grandson has already called his mother from jail, calling collect, of course, and saying, Mother, you better tell that prosecutor to back off, because I've heard that all he wants to do is put me in prison for 25 years to life. And so the victim is working under total false representations from her own, the accused, that I'm there to get him in prison for life, and I'm not. And it's typically, it's going to be 180 days to 365 days plus a subsequent period in a residential rehab program. And once she knows that, I can normally win her over. If I can't win her over and I have evidence, I'm still going to prosecute it anyway, whether she likes it or not. Yes?
I frequently have a dilemma of people. I'm a private attorney, and people come to me and ask me to draw up a power of attorney, and it's the caregiver child with senior citizen person, and it's my responsibility to somehow figure out whether there's any undue influence going on. People come to me and ask me to write a life estate or a quitclaim deed, and they want it right there on the spot, which I never do. But do you have any suggestions or thoughts as to how we can sort of assess these situations, whether, you know, things that should set off our radar right away?
The question is from a private attorney who is often asked by family members, caregivers, coming in with the senior citizen to execute powers of attorney, which on the face of it to the attorney looks like a potential conflict of interest. How can you, is there anything that you can do to assess the situation to actually figure out if there's anything sinister going on? I've always encouraged private attorneys actually to, if they feel comfortable, to try to assess the actual capacity of the client. There are some pretty basic tests. Whether or not your client feels it's a little derogatory for you to do that, but I like the fact that we can do it's called a Falstein mini-mental test, and you score out of 30, and it gives you a kind of a good rough and ready idea as to whether or not the client has got mental capacity to make independent legal decisions on their own. You know, how long they have been associated with the caregiver, where did they find the caregiver from, sometimes maybe even call up Adult Protective Services and say, you know, I'm working with this client, and I've just got some concerns. Do you have any reports on this individual that I might need to be aware of before I make any decisions? And then ultimately, I think, just to protect yourselves, it's very good for the lawyer to refer this person, maybe the elderly person, to a second lawyer, just to have that second lawyer interview the elderly person independent of anybody else who's coming in, just to be reassured that there's no undue influence going on here. Yes?
You're probably doing this, but one thing I do is I ask the family member who might be serving as the agent to leave the building, absolutely walk out of the building, and then I ask, are you sure you want them present, etc.
Right. Yeah, I definitely do that. My concern was really more undue influence than capacity in any of it.
Right, right. Okay.
I agreed, their presence there, but they're also relying on that person to transport them home and take care of them going forward. So it's sometimes not real clear cut.
One more question? Okay, yes. Thank you.
Did you say Falstein mini-mental?
Yeah, Folstein F-O-L-S-T-E-I-N, F-O-L-S-T-E-I-N. You can find it on the internet. It has a series of 30 questions, scoring a point each, and it's not intended to be a fail-safe, foolproof test. You can't make any kind of professional evaluations from it, but it's a rough and ready guide. As somebody who scores less than 20, you would have serious doubts as to whether or not they have full capacity.
Test they give on Grey's Anatomy.
Oh, they give on Grey's Anatomy. Okay, so it's valid. It's on Grey's Anatomy. That's good. That's good to know. Okay, thank you. You know, as I wrap this up, and forgive me because I'm going to have to shoot out of here in about 3 minutes and get on that freeway. But this is the message that I have for seniors. And I always finish with this: respect, honor, because that's where I started this morning, was talking about that generation for whom I have such respect for, and a commitment that I know that you have in this county and in this area of Virginia for seeking justice. And for prosecutors out there, I like the 3 Ps. I always like to finish my closing arguments into a jury with 3 words that reflect the trial using the same beginning letter. And I like the letter P because my name's Paul, I'm a prosecutor. I used to say I'm partial to P, but my doctor says at your age don't ever say that. But the 3 Ps that I want to leave with you: passion, purpose, perseverance. And I always admire people with perseverance. I want to share with you this, as we're in baseball season, this wonderful story that I heard last summer of perseverance. This is a guy, I think his name is Daniel Nava. I don't know if there's any Boston Red Sox fans here. Oh, there are. Okay. This guy, when he was growing up, all he wanted to do as a teenager, I want to be a Major League Baseball player. And everywhere he went, outside of his family, he was told, you're too small, you'll never make it. He went to junior college in the Bay Area, and they wouldn't even let him on the team. They made him their kit manager. And eventually he went to another junior college, and he was a walk-on. And finally, he started demonstrating for them what he knew all along he could do, which was play baseball. He played so well, so effectively, eventually he was signed up for the minor leagues by the Boston Red Sox. Last June of 2010, he got the call that he dreamt of as a teenager, to play in the major leagues. And last June, he called his parents, very excited from the Bay Area, and he said, I knew I could do it, I knew I could do it, and you've got to come out on Sunday. I'm playing for the Red Sox against the Philadelphia Phillies. And his parents dropped everything, they flew, and they literally arrived at Fenway Park as the beginning of the second innings. Their son was up at the batter's plate, and he was on deck to face his first pitch in the major leagues. The dad looked around, and he's turned to his wife and said, the bases are loaded. First pitch, grand slam home run. And it's only happened 3 times in major league history. And it just shows what's amazing, the perseverance that this young man reflects. So I just wanted to share that great story. Because when I read it last year, it just gave me great chills. Because, you know, those of you in law enforcement, the Dog Protective Services, Commonwealth's attorneys, and everyone else represented here, you may not know it at the time, but you can make such a difference in the lives of one senior citizen. And maybe in the next few weeks, you can hit a major league grand slam home run for somebody out there. So I just wanted to share that with you, and thank you so much. You've been a wonderful audience. Thank you.